Hello everyone, my name is Aaron. You may recognize me from YouTube or from my website, myhivjourney.me. But I'm excited to announce that I'm going to be doing blogs here at hipster.com. We'll be doing topics everything from health to politics to popular culture. You name it, we'll do it. So let's delve right into it. This week we're doing HIV criminalization. And what's it mean to you? When I say HIV criminalization, you may say, that has nothing to do with me. Well, listen to all the facts as I lay them out, and then you be the judge of that. Prosecutors are relying solely on an individual's positive HIV test result as proof of intent to harm, and it's the basis for irrational, severe treatment in the criminal justice system. 34 states and 2 U.S. territories have HIV-specific criminal statutes, and 36 states have reported proceedings in which HIV-positive people have been arrested and prosecuted, at least 80 in the past 2 years. Just listen to a few of these. A man with HIV in Texas is currently serving 35 years for spitting at a police officer. Spitting. A man in Iowa who is undetectable, viral load, received 25 years sentence after a one-time sexual encounter in which he used a condom. His sentence was subsequently suspended, but he had to register as a sex offender and is not allowed unsupervised visits with his niece, nephew, or young children. A woman with HIV in Georgia received an 8-year sentence for failing to disclose her HIV status despite trial testimony of 2 witnesses that her sexual partner was aware of her HIV status. A man with HIV in Michigan was charged under the state's anti-terrorism statute with possession of a biological weapon after he allegedly bit his neighbor. Some of the charges that we can face: reckless endangerment, assault, terroristic threats, homicide, and attempted homicide. The United States Supreme Court has upheld the use of involuntary civil commitment or confinement of HIV-positive individuals. Such measures have been used against those with HIV in recent cases, suggesting that a defendant's history of unprotected sexual contact without disclosing his or her HIV infection is adequate to meet the statutory dangerous statute for confinement. A more recent and perhaps more pernicious trend is the indefinite detention of persons with HIV under sexually violent predatory confinement statutes. Such statutes were upheld by the Supreme Court in Kansas versus Hendricks and have been applied to people with HIV based on sexual activity posing no risk of HIV transmission. Missouri, the state in which I live, condoms are no defense. For simple HIV exposure, it's a Class B felony punishable by up to 15 years in prison. And if the person does contract HIV, up to 30 years in prison. Disclosure alone does not ensure that you will not be prosecuted. And for simple acts that we know does not transmit HIV, such as spitting, you can still get 5 to 30 years in prison. Sexually violent predatory statutes have been applied to people in Missouri based solely on their HIV status. If you're in Washington State, first-degree assault is what you'll face, and that's a Class A felony, punishable by up to $50,000 fine and life in prison. First-degree assault is a person is guilty of first-degree assault if he or she, with the intent to inflict great bodily harm, administers, exposes, or transmits another to HIV. If you're in New York law is not defined on whether there is a criminal penalty for HIV exposure. HIV positive people have been prosecuted under general law, such as sodomy, assault, attempted homicide. New York courts have found that HIV can be considered a deadly weapon. And in 2007, a HIV-positive man was found guilty of aggravated assault and sentenced to 10 years in prison for biting a police officer. The judge in the case said that the saliva of an HIV-positive person could be considered a deadly weapon. In California, a person who exposes another to HIV through sexual activity and has not disclosed their statuses and acts with the intent to infect is guilty of a felony, punishable by up to 3, 5, or 8 years. Now, it's important to notice that a person's knowledge of his or her HIV positive status is not sufficient to prove specific intent. You can also be charged with a misdemeanor, willful exposure of yourself or others to a disease. You see, this is really a slippery slope that we live on. Today it's HIV, but if tomorrow you transmit herpes or cancer or some other disease, what's the law going to do? Are they going to arrest you? Are they going to hold you indefinitely in prisons? That's really a question for you to ask. But if you have an HIV positive status, HIV criminalization is a topic that you need to take interest in. As a disclaimer, it is important that while we've made all efforts to ensure the information contained within this blog is accurate, the law is always changing and we cannot guarantee the accuracy of the information provided. The information may or may not be applicable to your specific situation. As such, it should not be used as a substitute for legal advice. For more information on laws that apply in the state in which you live, please contact the Positive Justice Project at www.hivlawandpolicy.org. Remember, if you have a topic that you'd like me to cover, please comment below. And until my next blog, do something positive.